Most counties on first DUIs, the fines are statutory. What I mean is the fines are set. Unless you get a reduction to a wet reckless, which cuts your fines in half and eliminates the work project, the fines are what they are. They're anywhere between $2,500 to $3,200 in the counties in Northern California. Most counties do not require jail time on a first DUI. Now the code says 48 hours in custody minimum, but they let you do alternative sentencing, and alternative sentencing in most counties means work project on the weekend where you're doing 7.5 hours or something out there working. It's not usually on the freeway where your neighbors are going to drive by. On a first DUI, depending on your alcohol level, and there are arguments you can make in court that you're below the level if you had, say, PAS tests below, say, 1.5, and your tests later at the jail were 0.15, which is the first threshold for high blood alcohol. You can sometimes argue for the shorter DUI program. First DUIs, you're either going to be doing a 3-month, a 6-month, or a 9-month version of the first offender program. If all your tests are 0.20 or higher, then you're going to do the 9-month program. If you're between 1.5 and 1.9, 6-month program. And if you're below that, then it's a 3-month program. If you want your license back, you have to take that program. It has to be licensed by the state of California, which raises a real issue for people who are out of state who come here. Let's say somebody comes here and they're in the high blood alcohol range, and they're ordered basically to take the 9-month program. Well, if they're living in another state, you can ask the judge to basically stay indefinitely the requirement to do the program because they're not living here, and if they end up moving here, then they have to take it in order to drive. But the problem is they've got a suspension just sitting there, and there's not much you can do about it because California only allows California licensed programs for this. Years ago, you could get an equivalent program out of state, which makes a lot of sense, but somebody saw dollar signs, I think, and so you're required to do that. So it's a problem. One of the things on that issue, since I brought it up, one of the things on that issue is that if you are living out of state, the first thing you need to do when you go back is apply in California for a waiver of the program. It takes 3 years. So that if you ever come here or anything else after that 3 years, then you're not required to do it and the suspension will be lifted. You won't have the suspension, which some states will honor. So in other states, you may be required by that state, based on the DUI in California, to take a program there just to drive there, but you don't get any credit for that here. So, people that travel for business, et cetera, it can be a problem. They're probably using Uber or Lyft or something in the interim. With the high blood alcohol, 0.2 or higher, it's technically a 10-month suspension. That doesn't mean you can't drive for 10 months, although the paperwork kind of makes it look like that sometimes. It's that you'd have to stay on a restricted license, or in Sacramento, if you have an ignition interlock on a first, which is required on first DUIs, then you just have to leave it in so you can keep driving. The advantage, by the way, to the ignition interlock in 4 counties where they're required on first DUIs is that you can drive anywhere, anytime. You're not restricted in your driving. Some counties do require 48 hours in custody or more. You've really got to argue mitigation. I think I had one case where I had a PAS test closer to 0.08 and I got my client out of the jail time, but it's a little harsher in some counties. Second DUIs, there is a 96 hours in custody, mandatory custody requirement. People have to do 96 hours straight, which is a problem sometimes for your job. But then on the balance of your sentence, and the minimum is 10 days on a second, then they let you do work project and you get 50% credit off of that. On third DUIs or felony DUIs, you can get an ankle bracelet sometimes in lieu of most, or in some cases all, the jail time in Sacramento and some other counties. In other counties, though, like Placer County, no. You do get alternative on some of it on seconds, but on thirds, most of the time you got to do the whole time in. Sometimes you get out early, and I do believe they're giving 50% credits now, but I'm not aware of any diversion programs, and also people ask a lot about doing an online DUI program. That's not accepted in any of the counties I've worked in. They make you do the actual physical one, and there's no way to speed it up or anything else. You just have to do what they require. I think first DUIs is 30 hours, but they spread it out over 3 months on the minimum one. So yeah, it's because of all the political energy that goes into these, and the way it gets a little bit overblown. I'm not saying it's not serious. Of course it's serious. But most first offenders don't ever reoffend. If they did, I'd have a lot more repeat customers than I do. Not that I want that. But most first offenders do not reoffend. So this idea that we have to keep upping the sentencing on first offenders continually, since I've been doing this over 20 years, I've seen these sentences just climb and climb and climb. What's the rationale? I mean, there's more political hysteria about it, but is it really appropriate? And so that's part of what you have to fight against. Some counties will let you do what's called community service. That's not the same thing usually as work project, which is under the supervision of sheriffs. Community service is where, and it's less available now than it used to be 10, 15 years ago, where your client would do volunteer work. And then you have to come back to court after a period of time and prove that the person did all these hours in lieu of the sentence, which on first 2 days converted to 60 hours. That was based on some old code. Didn't make any sense. But you have to do all these hours, and then you have to come back and prove it in court, and then that gets you out of it. And in some cases, when that's available, clients can convert almost half their fines to community service as well. It does cost a little money for community service, but it saves people a lot of money. It helps the community, and I wish it was more available, especially on first DUIs, because, like I said, low blood alcohol first DUIs. People are often not impaired. The prosecution argues that your point, everyone is impaired at 08. Well, that's not really true, and there are problems with testing. There are things that you can attack, even though they are generally very accurate. It's this one-size-fits-all thing doesn't really work. We already covered a little bit on sentencing, the fact that alternative sentencing is available on first DUIs. It's available in most counties on the balance of a second DUI sentence. So that in Sacramento, for example, you have to do 96 hours in custody. It's straight time now. And so the fines are similar. You're looking at least 90 days no driving. It's technically a 1-year suspension on a second. The fines are about the same. The program is an 18-month program on a second or a third on multiple offenders within, if you have priors within 10 years. 18-month program is really 1 year of a program. It's a little more intensive than the 9-month program for first offenders. But then it's 6 months. The last 6 months are what they call aftercare, where they check on you once a month, that you have to come in and maintain that. So you'd be once you get a restricted license with the IID on a second or a third, it takes longer on a third, then you can drive around, but you'd have to leave that thing in your car until you're completely done with the program. Then you get your license reinstated in full. Third DUIs, it's technically a 120-day minimum. The fines are a little higher, maybe, not a lot higher. They're all in the same kind of range, $2,500 to $3,200 or so. There's also an 18-month program requirement. Sometimes people have 2 DUIs, a second and a third. Then you're going to ask the court to order that the person can do it one time, and it takes care of both cases. Most of the time, the judges will go along with that. So you're not doing an 18-month program twice. Fourth DUIs, felonies. Sometimes you can get jail time and probation. It depends on when your priors were, how serious they were, those types of things. What your blood alcohol was, how bad was your driving, what's your history, and what's the jurisdiction. Now, DUIs with injuries are a little different. DUIs with injury, causing injury to another person, not yourself, can be misdemeanors or felonies. They're what's called wobblers. In criminal law, I do a lot of criminal cases too. Wobblers means that it could either be a felony misdemeanor. There is a motion you can make at any point called a Penal Code 17B motion that you can even do in negotiations, and a judge can override the DA, or if you're charged with a felony and you're in a preliminary hearing, if you raise enough doubt about the injuries, usually in this situation it's the scope and nature of the injuries. If you cause someone to have a broken bone, even a finger, well, that's a felony. In any felony type DUI with injury, your first goal is to try and get a misdemeanor. Under the law, you only have to be 1% at fault to be 100% criminally liable. As far as the great bodily injury enhancement, that's usually negotiable. I mean, it does make a difference. It's important. It creates a strike if it's a felony. So in Placer County, DAs do not want people to do an ankle bracelet at all. They think it's too easy. It's, I understand sleeping in your own bed is easier than jail, but part of my job, I feel like part of my job a lot of the time, or a big part of it, is trying to save people's jobs, to get the jail time down to a point where, or put the case in a time frame where the person can take time off. And that's a lot of what I'm doing a lot of times is really trying to find a way and make the argument to the judge. How does this help anyone if this person loses their job? I mean, if we can find a compromise here so that the person keeps their job, that's kind of critical. And I think it's a benefit to society that the person's working, that they're taking responsibility, etc.